So, we have now so far seen different kinds of cyber crimes, and on all these cyber crimes, we find that the criminals are becoming much and more intelligent, more and more cyber savvy, and then they are challenging the capabilities of the police officials. So, in that, one of the methods which helps them most is that encryption. They encrypt all the evidence relating to their criminal acts. And so, supposing you use WhatsApp, or you are in a WhatsApp group of all cyber criminals, whatever you discuss in the WhatsApp, it cannot be seen by anybody, including WhatsApp itself. So, that kind of a encryption is now available easily and openly. Next, the commonality among different kinds of crime is offender to a great degree depends upon the lack of technological skills of the law enforcement to successfully commit offences and escape undetected. The cyber criminals, their strong point is that they know how tech savvy the police are and how they are not tech savvy, either both of them. So they'll find out methods of being one step ahead of the police so that they can commit the offense and escape undetected. So this cyber life has become a part of our education, shopping, entertainment and business. So you cannot escape being a victim of cyber crime. Remember one thing, it is only a question of how serious the crime is going to be and how frequently are you going to be a victim if you are not on your guard. But everybody who uses internet or a computer is going to be one day or the other a subject of cybercrime. Now, other definitions, we'll see cybercrime definitions because we are discussing it as an academic issue. Now, one person has, two authors have given this name: offences that are committed against individuals, number one, or groups of individuals, number two, with a criminal motive, number three, to intentionally harm the reputation of the victim, number four, or cause physical or mental harm, number five, or cause loss, number six, to the victim directly or indirectly, number seven, and using modern telecom network like internet, chat room, notice board, group, MMS, SMS, etc. This is fairly comprehensive. Then one more Oxford Dictionary definition is: cybercrime is criminal activity carried out by means of computers or internet. Cybercrime may be said to be those species of which genus is a conventional crime, whether either the computer is an object or a subject of constituting the crime. Cybercrime means any criminal or other offence that is facilitated by or involves the use of electronic communication or information system, including the device, internet or any of them. Professor S.T. Vishwanathan has given the following definition. 1. Any illegal action in which a computer is a tool or object of the crime. That is, any crime, the means and the purpose of which is to influence the function of a computer. Second, any incident associated with computer technology in which a victim suffered or could have suffered loss and a perpetrator by intention made or could have made a gain. Next, computer abuse is considered as any illegal, unethical or unauthorized behavior relating to automatic processing and transmission of data. The nature and scope of cybercrime. Cybercrime is essentially a socially correlated phenomena. So, it is part of sociology. The jurisdiction of law is a big issue here, and the courts are unable to decide the proper forum to entertain cases involving cybercrime, as cyberspace is basically borderless. Next is the doctrine of mens rea and actus reus in cybercrime. We have already, I told you in the earlier law general concepts, there are two concepts that are related to crime. They are mens rea and actus reus. Mens rea is a guilty mind, actus reus is the guilty act. Traditional crime is concerned with mens rea and actus reus. Actus reus means such a result of human conduct as the law seeks to prevent, and it can be a commission or an omission. Mens rea is a guilty state of mind. It is very difficult to determine the mens rea in cybercrime. We have to establish that the hacker knew that the access was unauthorized, first part. A particular computer need not be intended by the hacker. It is enough if the unauthorized access was to any computer. Then awareness is easier to prove when he is an outsider and has no authority that he can provide, that he has authority to access. And hacker already has a limited authority when in case he is already an employee and he is trying to hack into the boss's computer. Then you can only establish his mens rea when you can say he exceeded his limit and was even aware that he is exceeding his limits. Next, the characteristics of cybercrime. There are peculiar characteristics of cybercrime are there. First, the criminals are people with specialized knowledge. Contrary to the general idea that criminals are less educated than the victims, here criminals are much more educated than the victims. Geographical challenges are there because a criminal can sit in any part of the world and commit crime in any other part of the world. And it's a virtual world where a criminal is physically outside the cyberspace where he is committing the crime. And collection of evidence, it depends on jurisdiction of several countries, and the criminal may be sitting in a safe place where he is not traceable. Actually, many of these spam, phishing and other internet crimes, you will find that the IP address of the person who is starting the cyber attack, it changes and jumps all over the world, whereas actually the person may be sitting next to you. Magnitude of crime is unimaginable. The cyber crime causes unimaginable injury and loss of life. Classification of cybercrime. Next, this usually involves the modification of the conventional crime by using information technology. Now, one of the major things I told you, some of the major items we will discuss in detail. Here, cyber pornography will start. This is one of the major issues in India is cyber pornography. Now, first question is definition of pornography itself. It refers to any work of art or literature dealing with sex and sexual themes. The second issue is whether it is termed illegal or legal. In some countries it is legal, whereas in some other countries it is illegal and punishable. In India, we have a dual mindset. In some places we call it as illegal and punishable. In some other context we don't consider it as illegal and punishable. And cyber pornography is an act of using cyberspace to create, display, distribute, import or publish pornography or obscene materials. We do not have a uniform standard, culture and ethics in the world, nor do we have uniform laws. Obscenity and pornography are normally used interchangeably, but they vary. The definition also varies from country to country. Indian law does not define pornography nor deal with the item pornography. In modern world, sex sells and sells extremely well. So every businessman who is down, wants to make money, will jump at the opportunity to sell pornography on the line. Information technology has made it easier to create and distribute porno material through internet. Such material can be transmitted all over the world in a matter of seconds. Now, test of obscenity and pornography. The issue with law is we have to first define the crime. Unless you define the crime clearly, you cannot punish anybody. Now, there are two terms which are used very frequently in the context of pornography. One is obscene, the other is porno. Obscene is much easier to define. Here obscene is criminalized in India, and it is defined as a depiction of nudity, sex or excretion in a patently offensive manner without artistic or scientific value. The crucial part here you have to understand is with or without artistic or scientific value. In India, many of the Supreme Court judgments have said that in case there is an obscenity, there is a porno material, but it is associated with either art or religion or science, and then the benefit arising out of art, religion or science is much more than the negative effect of the porno image itself, then the image porno or obscene content has to be ignored. So In the case of obscenity, first case was Regina versus Hicklin. It is defined as a tendency to deprave and corrupt. Always remember these words, they come again and again. Deprave and corrupt. The minds which are open, young minds which are open to such influence, and into whose hands the publication will fall. It was understood that this test will apply only to isolated patches of work. Next case where it was dealt with is Miller versus California. The Supreme Court of United States issued guidelines and a 3-point test. What is the 3-point test to decide porno or obscene? One, that the average person, always in law, we use a rational person, an average person, a normal person as a standard. Here the average person, applying contemporary community standards, would find that particular work taken as a whole, not part by part, appeals to a prurient interest. This is another word, always remember, prurient interest. Next, the word depicts or describes. The work depicts or describes in an offensive way. There is another word you remember, offensive way. Sexual conduct or excretory functions as specifically defined by applicable state law or applicable law. Third is whether the work taken as a whole, again another word phrase you have to remember is taken as a whole, lacks the serious literary, artistic, political or scientific value. Now the next case is Roth versus United States. Again they use the average person standard which appeals to prurient interest, whether the work is appealing to the prurient interest based on an average person's application of standard. Obscenity is a 5-part structure. They have again defined it as a 5-part test. 1. The perspective of evaluation was that of an ordinary reasonable person, distributed from the viewpoint of an ordinary reasonable person. Second, the community standards of acceptability are to be used to measure obscenity. Obscenity law will only apply to works whose theme is in question. A work, in order to be evaluated for obscenity, had to be taken in its entirety. An obscene work was one that is aimed to excite individuals' prurient interest. In India, we use the Miller test and the Hicklin test. In case of Ranjit Udeshi versus State of Maharashtra, they said work as a whole must be considered. It should be so gross and it should deprave and corrupt the minds of young people who are open to influence, and it should not be in the interest of contemporary society, and you have to strike a balance between freedom of speech and expression versus the public decency and morality. Where the latter, that is public decency or morality, is substantially transgressed, then the freedom of speech and expression must be given go by and you should be punished. Sex and nudity in art and literature, again the court said, cannot be an evidence of obscenity, because we have a culture of using these images everywhere in our culture. Then another case, Samresh Bose versus Amal Mitra, Supreme Court held that vulgar writing is not necessarily obscene. Vulgarity arouses a feeling of disgust and revulsion and also boredom, but is not depraving, debasing or corrupting the morals. So therefore it is not obscene. The judge, they say, should place himself in a position of a reader of every age group and then decide. IPC 1860 deals with the issue of obscenity. Section 67 of IT Act 2000 deals with obscenity and porno content. Section 67 says, lascivious appeals to prurient interest, tends to deprave or corrupt persons. This is the effect. Material is to be judged based on its effect, and the effect should be lascivious, appeals to prurient interest, depraves and corrupts persons. If it is a first conviction, it is for 2 to 3 years and 5 lakh of rupees. If it is a repeat offender, 5 years and 10 lakh of rupees. And in 67, in Udeshi versus State of Maharashtra, emphasis was given on knowingly and negligently. Thus, mens rea is associated with knowingly and negligently to establish guilt. The difficulty of obtaining legal evidence of the offender's knowledge of obscenity of the book has made the liability a strict liability. Under 67, strict liability means what? You don't have to really bother to prove their mental condition. If you have done a particular act, you will be punished based on the act that you have done. That is strict liability. In Ranjit Udeshi case, under 67 Act, IT Act 2000, concluded that mere publication and transmission of obscene material is an offence. That is under strict liability. You have published, yes sir. You have transmitted, yes sir. You are guilty. That's all. Sir, I didn't intend to it. Nobody bothers about it. Next is child pornography as a menace in the modern world. Next, pornography is over. Next is a much worse form of it, child pornography. It is about sexuality and sexually explicit material. Sex offenders exploit children. The child in this tender age does not understand or recognize the potential danger, and they become victims to the aggression of the pedophiles. Parents themselves also don't appreciate or don't understand the problems. And then 67B 2008 has been inserted. What says is that whoever publishes or transmits any material regarding children engaged in sexually explicit act or conduct. Next, whoever creates or promotes any act of depicting children in obscene, indecent or sexually explicit manner. Then whoever cultivates, entices, that is, you are actively now engaging in an act with the person. Cultivates, entices, induces, that is, you are engaging with the child. Children to online relationship with one or more children and sexually explicit act in a manner that offends reasonable adult. Next, whoever facilitates abusing children online and who has own abuse or others abuse the children for sexually explicit act with children, he will be punished. First time 5 years, 10 lakh of rupees. Repeat offender 7 years and 10 lakh of rupees. 67A does not extend to any book वगैरह which is related to serving public good, or it is a part of a science, literature, art or learning, or it is part of a bona fide heritage or a religious purpose. Here children means anybody who has not crossed the age of 18 years. There was another case of Lieutenant Colonel Jagmohan Balbir Singh, who was tracked from Germany to US to Interpol to Delhi to Mumbai, and he was convicted for distributing online obscene material. Next, obscenity and freedom of speech and expression. Everywhere we come across obscenity is pitted against Article 19, freedom of speech and expression, 19.1. Freedom of speech and expression is recognized as a fundamental right, but it is subject to reasonable restriction to maintain law and order, public health, morality, decency in Indian Constitution. Freedom of speech and expression is restricted under 292 and 499 of IPC. The aim should be to defame someone through obscene material. But 19.1 gives the freedom of right, 19.2 gives reasonable restrictions on the 19.1 right. Now the reasonable restrictions under Constitution are sovereignty and integrity of India, security of the state, friendly relation with foreign states, public order, decency, morality, contempt of court, defamation or incitement to an offence. In a case Maqbool Fida Hussain vs Rajkumar Pandey, M.F. Hussain, the great artist, painter, the case was filed against him on Bharat Mata. He painted a picture of, there was another case of Ma Saraswati also. He painted all these things in nude form, in the nude. All these artists have a tendency to paint in the nude. They don't bother about the dresses. So complaint was filed under 292, 294, 298 of IPC, and then the court held that the aesthetic touch to the painting, because M.F. Hussain is a very great painter and each of his paintings are sold for millions of dollars. Then said aesthetic touch to the painting which reduces or dwarfs the obscenity in the form of nudity, hence it cannot be termed as obscene, and the case was dismissed. The court said literature of India, both religious and secular, is full of sexual allusions, sexual symbolisms and passages of frank eroticism, the likes of which are not found elsewhere in the world literature. So in India, we have to be much more liberal, and we have to prove to a very great extent, to a larger crime being committed before anybody can be punished under this particular obscenity and provisions. Next case is K. Abbas versus Union of India. The Chief Justice said, maintain public decency and morality. Film censorship has full jurisdiction. In case of Raj Kapoor versus State of Others, in the case of Satyam Shivam Sundaram, they said the certificate of censor board is of relevance, but it does not preclude the court from seeing the movie and deciding to itself whether it is obscene or not. Krishna Iyer said it is an act of moral worthiness by the statutory agency, not opinion. He also said arts, morals and laws, aesthetics are sensitive subjects where jurisprudence meets other social sciences and doesn't go alone nor straitjacket its prescription. So it actively participates one-on-one in administration of justice to aesthetics. Indecent representation of Women's Act 1986 is also related to pornography and obscenity as defined under section 3 and 4 of that act. Indecent Representation of Women Act has specifically prohibited indecent representation of women. In the case of J.S. Thakkar versus State of Maharashtra, they have suggested forming a committee to suggest and recommend ways of preventing and controlling to protect children from accessing porno and obscene material. So they said cyber cafes to maintain proper logs, to keep physical record with address, check with photo ID card and the person who used their machines. Regular users are to be given free membership, and the minors are to be restricted from both using the machines as well as visiting certain sites. Then another case in Delhi police, a student of Air Force Bal Bharati school, he was not very much, he had a pock-marked face. The other students used to abuse him, so he wanted to take revenge on them. So he was very intelligent. He put up a website, amazing-gents.atm.net, and then made comments about all his girl students and teachers of the school, and this was registered as a section under 67 under IT Act and Delhi Police Crime Credible Cell. Another case is Tamil Nadu versus Suhas Katti, where obscene and defamatory messages about a divorcee woman were put up in a Yahoo message group. There were annoying phone calls to the lady in the belief that she was soliciting, and this man finally turned out after investigation that he is a family friend interested in marrying her. She refused to marry him, married somebody else, but that marriage didn't work out. Again he approached her to marry him. She again refused him. Then he started all this harassment on the line. So charge sheet was filed under section 67 IT Act 2000, 469 and 509 IPC. He was convicted for 2 years and paid 500 rupees fine. That is the first case of conviction under IT Act. Another case of Bazi.com case, a sexually exploited video clip of 2 school children was shot with a cell phone camera and distributed by MMS. Mr. Raj, he was a software engineer. He benefited by selling this particular MMS online. So he was also arrested and jailed for 6 days. He was let loose because he has cooperated with the police in finding out who the real culprit was, and even the students were let off because the court said it is an act of misadventure by the students and nothing of a moral deprivation is not there. The Delhi government later on brought out a notification banning use of mobile phones by students as well as teachers in all government schools. In Chennai fast track court, an orthopedic surgeon Dr. Prakash was sentenced to life imprisonment. It is the biggest imprisonment so far under this, for taking obscene pictures of his patients and uploading them on the internet. Section 67 IT Act as well as under indecent representation of women read with 27 Arms Act 120B of Indian Penal Code. He was sentenced under that. Next case is Kamlesh Vaswani versus Union of India, where the center was asked to take steps and frame rules stop access of websites featuring child pornography by general public. This is all about child pornography. We have completed pornography, obscenity, indecency, then child pornography. Now we are coming to cyber stalking. Stalking means a behavior of harassing or threatening the other person. किसी के पीछे पड़ जाना, समझ लो दैट. किसी के पीछे पड़ गया, हाथ धो के पीछे पड़ गया. That's called stalking. Cyber stalking is an extension of a physical stalking onto the online medium or internet by way of internet, email and chat rooms. Wikipedia says it includes the false accusations, statement of fact as in defamation, monitoring, making threats, identity theft, damage to data or equipment, solicitation of minors for sex, gathering information that may be used to harass. Cyber stalking is repeatedly harassing or threatening of an individual via internet and other electronic means of communication. A cyber stalker is someone with an amorous or a sexual motive. Amorous means sexual, both. Stalking generally involves constant harassment or threatening of someone else. When you follow the person, you appear at someone else's house or his office, make harassing phone calls, leave written messages, vandalize someone else's property. Cyber stalking does not involve any physical contact. Normal stalking involves physical contact. That's the differentiation. Now, women normally are threatened, they are vandalized, they are assaulted when it comes to real world. But same things can also happen when cyber stalking takes place. Obscenity adds up with threats and harassment. Now, there are three ways cyber stalking is conducted. 1. You stalk by email. You send hate mail, obscene mail, porno material and threatening mail to the victim. Next is stalk through internet. You invade the private space of the victim. You find out their phone number, email address and post it on a porn site, and the stalker chases all activity of the victim on the net and posts false information about her on the websites. Third method is stalking through computer. You take control of the computer of the victim and start using it in the manner that is prejudicial to the interest of the victim. And you almost affect their former friends, employees and person who wants to force his will over the target. These are the people who are stalkers. He can be a dejected lover, he can be an ex-boyfriend, he can be a colleague who failed to satisfy their desire and wants to harass the victim. And victims are mostly women. The methods used by cyber stalker to target the victim is the stalker, if he is already an associate, he gathers all information about victim easily. If he is a stranger, he gets all information from the Facebook, वगैरह social network sites. He finds out their date of birth, place of residence, place of work, phone number, email ID, to place visits, everything by way of, and then uses them for a wrong purpose. The stalker may post all this information to a website which offers sex services or dating services. All people from the world would now call the victim and ask for favors, sexual favors. Some will send emails asking for porno material. Some may send email attaching their own porno material. Some will post morphed pictures of the victim indicating a particular sexual act. Sometimes the stalkers send them repetitive emails and call them day and night and keep track on them. So Facebook, Twitter, Google, Instagram, these are all become a medium of cyber stalking in our world. So be very careful in what you post online about your personal details. Next is legal recognition and position in India. Indian law does recognize cyber stalking. IT Act 2000 does not contain a provision cyber stalking and cyber bullying, but later on another amendment it was brought in. And Ritu Kohli's case is the first case in India. Mahesh Kathuria is the culprit. Manish was regularly chatting under the identity of Ritu Kohli. He took upon himself the false identity of Ritu Kohli and started using obscene, obnoxious language and distributing her residence telephone, inviting chatter to chat with her on telephone. So, Section 509, outraging modesty of Ritu Kohli, case was filed. By word, gesture or act intended to insult the modesty of a woman. Under 66A of the IT Act 2008, and 2008 directly addresses cyber stalking, but 66A unfortunately was struck down by Supreme Court. 66A contains punishment for sending offensive messages through communication service which is grossly offensive or menacing, knows it to be false, causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, ill will, and persistent. Electronic mail causing annoyance or inconvenience and is punishable for 3 years and fine. But unfortunately, 66A was in 2015 in Shreya Singhal versus Union of India case struck down by Apex Court, saying that it is violative of Article 19(1) or freedom of speech and expression and is not reasonable restriction. Then intrusion, now persons who are victims were filing cases under intrusion on the privacy of individual, which is punishable under section 72 and 72A of IT Act. Now, breach of confidentiality and privacy, he secures access to your electronic records without your consent and discloses this information to a third party, and such person is punishable for 2 years with 1 lakh of rupees. Punishment for disclosure of information in breach of a lawful contract is another method, where including intermediary, if under lawful contract terms you are not supposed to disclose it to a third party, but you disclose it to a third party with an aim to cause wrongful loss or wrongful gain without consent and in breach of the contract, then you are punishable for 3 years with 5 lakh of rupees. Then in the case 2012 Delhi gang rape incidents, Criminal Law Amendment 2013 was brought about along with section 354D of IPC to define and punish the act of stalking. 354D IPC says any man who follows a woman and contacts or attempts to contact such woman to foster, that is force, personal interaction repeatedly despite a clear negative indication or indication of a disinterest by such woman, then he monitors the use by the woman of the internet, email or other form of e-com and commits the offence of stalking, provided that such conduct shall not amount to stalking if the man proves that he has done it to prevent or detect crime, or he has the responsibility to prevent or detect crime by the government. It was pursued under any law or requirement imposed by any law. If these two exceptions are not there, then such a person is punishable for stalking and is punished for 3 years with fine. If it is a repeat offender, then 5 years with fine. In the case of Yogesh Prabhu, 4 months imprisonment or cyber stalking his colleague in a cargo handling firm in New Mumbai, Panvel, was found out. Victim's family were not keen on their relationship. He wanted to marry her. Family did not agree. He finally ended up threatening her, scaring her and stalking her online. Another case is 2011 Delhi University law student. He is accused of stalking and threatening a woman online. He created her fake profiles, made obscene phone calls, threatening emails, asked her to marry him. She refused. He assaulted her. He threatened her. Love jihad case, another 66A IT Act lodged in New Delhi. This is about cyber stalking. Pornography is over, cyber stalking over, child pornography is over. Now let us see cyber terrorism. Cyber terrorism is a phenomena very complex in the current generation. Terrorism attacks the state. Terrorism is always attacks the state and the society. Okay? Cyber terrorism is the convergence of cyberspace and terrorism. It refers to unlawful attacks and threats of attacks against computers, networks, information stored in them when done to intimidate or coerce a government or its people or its employees or officers or ministers in furtherance of a political or a social objective. To qualify as a cyber terrorism, attack should result in violence against persons or property, or at least cause enough harm to generate fear. Terrorism is nothing but gaining power over other persons by generating fear. Terror is equal to fear. Attacks that lead to death, bodily injury, explosion, severe economic loss would be examples of cyber terrorism. Serious attacks against critical infrastructure are parts of cyber terrorism depending on the impact. Attacks that disrupt non-essential services are mostly a costly nuisance. NATO defined cyber terrorism as a cyber attack using or exploiting computer or communication network to cause sufficient destruction to generate fear or intimidate a society into an ideological goal. UN Infrastructure Protection Center, Homeland Security, they defined it as a criminal act perpetrated through computers, that is using computers, resulting in, always the firm, remember, the result is more important, resulting in violence, death, destruction, and as a result creating terror for the purpose of forcing the government to change its policies. FBI defines terrorism as cyber terrorism is a criminal act perpetrated by the use of computers, telecom capabilities, resulting in violence, destruction, disruption of services to create fear by causing confusion and uncertainty within a given population with the goal of influencing a government population to conform to a particular political, social or ideological agenda. A universal definition now finally all put together is it is a criminal act, number 1, perpetrated by the use of computers and telecom equipment, number 2, results in violence, destruction, disruption of services, number 3, to create fear within a given population, number 4, with a goal, ultimate goal of influencing a government or population to bow down or conform to your own political, social or ideological agenda. Right? Now, objectives of cyber terrorism, what are they? The first objective is, it is the organizational objective of cyber terrorism include recruiting, instigation, training, fundraising, communication, planning and spying. Terrorist groups, they recruit to internet on a daily basis. Their lifeline is always internet. That's why nowadays you see whenever a terror attack happens, first thing the government does is cut off all internet. Second is self-explanatory. The goal which terrorists seek to achieve here is to hinder the normal functioning of systems, services and website. They deface, deny or expose. And the purpose is directed towards achieving a classical terrorism effect by cyber terrorism using cyber technology and internet. Pure cyber terrorism was not there, we have not faced in India, but other areas, other countries they have. We have to find out whether the threat is real or not, because you have to define a terrorist attack in terms of the result. If it results in some loss, death, mayhem, then only a particular act is a terror. An attempted terror attack, cyber terror attack, a failed cyber terror attack or a rehearsal of a cyber terror attack is no cyber terror attack. That you remember. Whether the threat is real or not, whether it is affecting security community, IT industry, defense sector, politicians and experts. Okay? Most critical infrastructure is run by computers, and if the hijackers or hackers, they cripple or disable the military, finance or service sectors, then it is a terror attack. The more technologically developed a country is, the more vulnerable it becomes to cyber terror attack. Recent incidents of cyber terrorism in the world, what are they? First is cyber attacks in Middle East. In the Middle East conflict, pro-Palestinian, pro-Israeli cyber groups have been launching offensive against each other's websites. India and Pakistan conflict, pro-Pakistan cyber terrorists have attacked Indian G-Force, Dr. Newkar. These are the people who attacked Indian computers. Next, China versus India. Retribution by China. China has also attacked many countries as cyber attacks, including US. Cyber attack by Tamil Tigers. Sri Lanka, they attacked Indian as well as Sri Lankan computers when they were fighting with their government. In Yugoslav conflict, NATO airstrikes. All of NATO's 100 servers were DDoS, were given a distributed denial of service attack by Serbian, Russian and Chinese sympathizers of Yugoslavia. Then cyber attack in Estonia, small Baltic country. Estonia is in Eastern Europe. It was cyber attack from Russia because it was trying to go towards NATO. It wanted to join NATO. Now war is happening between Russia and Ukraine. Only on one point, because Ukraine wants to join NATO. The Estonian Defense Ministry said, "We have been lucky to survive this. If an airport, bank or state infrastructure is attacked by a missile, it is clear war. But if the same result is done by true computers, then what do you call it? Is it a state of war?" Then no answer is there so far. Then the case is Sony PlayStation Network, Microsoft Xbox Live Network cases in 2014. Sony has faced a lot of losses. Microsoft has faced a lot of, their entire packages were replaced, entire boxes were replaced. Next is Indian law and cyber terrorism. So we always talk about terrorism, cyber terrorism. Okay, we have enacted act which says punishment for cyber terrorism as follows. Section is 66F. Whoever with the intent to threaten the unity, integrity, security, sovereignty. These are the four things. The aim should be threaten the unity, threaten the integrity, threaten the security, threaten the sovereignty of India, and to strike terror in the people or any section of people by denying or a denial of service, attempting to penetrate or access a protected computer resource, then introducing any virus or other things like that under section 70, knowingly or intentionally penetrating or accessing a computer resource without authorization or beyond authorization. Whoever commits or conspires to commit cyber terrorism shall also be punishable as a person, and the person who is committing it will get imprisonment for life. Counter strike through aggressive defense is what the state uses, legal and law abiding. Chinese hackers tried to attack DRDO and they counter-attacked. Threat of cyber attacks remains imminent. Everybody, every country, especially India, is subject to cyber attacks. Indian cyber security needs to be beefed up. The following cases of cyber terrorism in India are: 1. 2012, anonymous group led a DDoS attack against government websites. 2012, hackers from Algeria, Muslim country, attacked DRDO, PMO and other departments. Number 3, hackers from Pakistan and terrorist organizations, they attacked J&K, G-Force. Here's the group. They attacked BARC. Indian Parliament attack is one of the deadliest attacks on Indian democracy. They downloaded the official logo and made forged passes for the cars so that the car could go very deep inside and make an attack. March 2016, Indian infrastructure was attacked by terror outfit of Al-Qaeda. IT became an easy tool in the hands of terrorists. There were hackers attack on American Center in Kolkata and Pathankot terrorist attack. As per cyber law and cyber security, the threat landscape remains very threatening. India is awakening to the global threat of cyber warfare now. Our cyber security is still ineffective and mass awakening is required. NTRO and DRDO are mandated with cyber offensive work. Only time will show. They are not yet up to the mark. Then a Norton virus maker Shantanu Ghosh said the past few years have witnessed a dramatic shift in threat landscape. Motivation of attackers has moved from fame to financial gain, and malware is a successful commercial business model. Most of the companies, when they are attacked, they pay up instead of protecting themselves. Next is hacking and other things. Hacking is the most serious of all cyber crimes. It erodes the faith of people in IT and internet. Hacking as a computer implies getting another computer without getting into another's computer without permission. Gaining unlawful access is hacking. Unauthorized entry into computer belongs to another is hacking. It is also equivalent to a phone tapping. Firewall technology, intrusion detection systems are prevention. And hacking per se is a criminal trespass into a computer into a private property. There are different hats. Okay, there are some hackers who are ethical hackers, white hat, some hackers who are criminal hackers. Here is a short list of global greatest hackers of the world. Most famous hacker in history is Kevin Mitnick. At 17 years in 81, he hacked into a phone exchange to redirect subscriber calls in any way he wanted. Then Gary McCannon, an Englishman arrested in 2002. He hacked into 90 US military computers. Vladimir Levin, Russian computer expert, he hacked into a bank to steal money. 1995, he hacked into Citibank for 10 million. Los Angeles radio station announced a contest for 102 caller called Porsche 944S2. He took control of the entire telephone network. US-based hacker Timothy Lloyd planted a malicious software code in a computer network of Omega Engineering, which is a prime supplier to NASA and US Navy. Species of criminal trespass have been treated with a more deterrent punishment. Punishment for house trespass is 1 year, but hacking it is lurking trespass and things like that. But hacking it is 10 years or even life imprisonment. Another hacking is by internet security companies who test the computer systems of their clients and potential clients to impress them and get business assignments. Hacking is also committed to damage business of competitors and enemies. Hacking is done at a country level also. Pakistan against India, China against India. Hacktivists are there who hack on behalf of different countries. Therefore, numerous species of hacking are there. Hacking is a skill. The seriousness of hacking depends on the nature, purpose, intent, and extent of loss or injury. Webjacking is a kind of a hacking where you take over a website. The various hacking could be a tool to commit cheating, misappropriation, criminal breach of trust, theft, copyright violation, spying, and wage war against the state. Section 66 IT Act. He defines hacking with a computer system. 1. Whoever with the intent to cause or knowing that he is likely to cause wrongful loss or damage to public or any particular person, he destroys, deletes, alters any information residing in a computer resource or diminishes its value or utility and effect is injuriously by means of commits hacking. Whoever commits hacking is punished with 3 years and 2 lakhs. 66 is the only hacking of computer systems. Now IT Act 2000, various type of hacking are access to a computer, downloading, copying or extraction of data from a computer, introducing computer virus or contaminants, causing damage to a computer, causing disruption from the computer working, causing denial of access to the computer, affecting critical information infrastructure, and cyber terrorism. This is about hacking. Rest are virus and other things we'll deal with on some other day. So we'll stop here. It has been a 1.5 hour. Any questions, please? Any questions?
No, sir.
Yeah, shall we stop here? Yeah, next class I'll take day after tomorrow because I have to prepare this some detail with some detail. So I'll take day after tomorrow. I'll prepare tomorrow and take day after tomorrow. Okay?
Thank you, sir.
Thank you. You can go out. What is hacking? Hacking is getting into another's computer without his permission. There are only two things here: getting into the computer, and second thing is getting into it without permission. That is hacking. There are 2 or 3 types of hacking. One is hackers who like to see the weakness in the target computer program. And there are those who work for firewall companies, antivirus companies, and work on the intrusion detection systems as preventive measures. So you have various kinds of hackers who depends mainly on the mental element, mens rea. Whether you want to help the company overcome, whether you want to help the general public overcome, or whether you want to really make money out of your activity. These are 3 ways. So you can have different hats for hackers, is what they call. So hacking per se then is a criminal trespass into a computer that is a private property. So under IPC, criminal trespass is defined as entering into a property in the possession of another with an intent to commit an offence or to intimidate, insult or annoy any person in possession of such property, or having lawfully entered into it and upon such property by unlawfully remaining there with an intent thereby again to intimidate, insult or annoy such person, or with an intent to commit an offence. So criminal trespass entails a punishment of up to 3 months and 500 rupees, or with both. Criminal trespass per se is thus a minor offence. But under Information Technology Act, it has been extended and then punishment has also been increased, as you have seen already. Let us see the most famous hackers in history. One is Kevin Mimic. At the age of 17, he hacked into a phone exchange in 1983. There is Gary McKinnon. In 2002, he was arrested for hacking more than 90 US military computers. Vladimir Levin, a computer Russian expert, in 1995 he hacked into Citibank and robbed $10 million. A Los Angeles radio station announced a contest to catch a hacker called Porsche 94482. US-based hacker Timothy Lloyd planted a malicious software code in the computer network of Omega Engineering. Thus, for species of criminal trespass have been treated with more deterrent punishments. Punishment for house trespass is up to 1 year. House trespass in order to commit an offence punishable with death is punishable with imprisonment for life or rigorous imprisonment up to 10 years. House trespass in order to commit an offence punishable with life is punishable up to 10 years. House trespass other than the above entails a punishment of 2 years, and it is theft then extend up to 7 years. For house trespass committed after preparation to cause hurt, assault or wrongful restraint, or putting any person in such fear, the punishment prescribed is 7 years. So you have various levels of punishments: 1 year, 2 year, 3 year, 7 year, life, things like that. Now it is all the purpose and the preparation. The 2 things that you have to see is the purpose for which you are doing and the preparation which you make, and what is the finally, whatever crime you commit, what is the, or you are about to commit, you attempt to commit rather. So what is the punishment given for that one, and depending on that your trespass is punishable. Now for normal house trespass, lurking house trespass or house breaking is punishable with 2 years. So lurking house trespass or house breaking, to commit an offence is for 3 years, and intended offence, if theft is there, then it is 10 years. The punishment for lurking house trespass or house breaking by night is for 3 years, and grievous hurt caused while committing such a trespass is imprisonment for life or 10 years. All persons jointly concerned in a lurking house trespass or house breaking by night are liable for the same punishment, whatever be your actual activity. There will be a group of persons who do the particular act, but each of them will have equal liability, even though some of them may do the particular act and others will not do it. So the mischief is there, another method. It is also dealt with under IPC with differing punishments. many of the offences in IPCs like robbery, criminal breach of trust and cheating, they also combined with these computers will lead to various IPC crimes and information technology crimes. So all forms of hacking, therefore, what we have understood is they cannot be treated alike. So what is the distinction here? The distinction is the purpose for which you are going, the damage that you want to cause, how much preparation have you made, what kind of activity do you do, whether you attempt or you succeed. These are the 5 things that happen. So based on that, the person or a hacker is punished. So many teenagers, they do it for fun and excitement, to show their capability or knowledge. So then it is the lowest level of hacking into a computer system, and then they are punished accordingly. Then the internet security companies, in order to test the computer systems of their clients and potential clients and to impress them and get business, they also do such hacking. This is to damage the business of competitors. This is third category. Second category, if you are trying to help a company find out the defects in their system, then you are a white hat hacker and you are not punishable. You are actually doing a service to the company. Then there are others who want to damage the business of competitors and enemies. They want to disrupt a computer and denial of service into a person authorized to access any computer. Some of the damage is caused by hacking. So if there is also a possibility that countries will hack into one another's computer systems. That's for spying and stealing information, and even for finding out the details about weapons and using it as a weapon. Hacking can be used as a weapon for cheating or misappropriation of funds. Hacking is done at a country level. When Pakistani hackers hack into Indian websites, SEBI site was hacked. There are activists who want to put up or let the world know about their viewpoint. So these people, if they use hacking as a method to put up their viewpoint or their posters, they are called hacktivists. So their punishment will be only very small, depending on what purpose they are doing. If they are a terrorist organization, it will be more. But if it is just a public issue, they are trying to protest, then the punishment will be very, very less. There are numerous species of hacking. In a sense, it is an offense of criminal trespass. Okay. Now, what you are trying to do here is find out the purpose. The seriousness of hacking depends on the nature, purpose, intent and extent of loss and injury. These are the 4 things that you have to remember. That is very, very important for you to understand. Is that the nature of the trespass or hacking, purpose of hacking, intent of hacking and extent of loss and injury that is caused to it. So under IT Act, Section 66 covers hacking. Section 66 of IT Act covers hacking. This is apart from the IPC provisions. This is apart from the IPC provisions of criminal trespass. Now what does it say? It says hacking with a computer system. Number 1, whoever with an intent to cause. First is intention to cause. Second, knowing that he is likely to cause a wrongful loss or damage to the public or any particular person. Then what does he do? That is, one is intention is that. Second is he knows that whatever action he is taking is going to cause a loss. These 2 things. One is intent, second is knowledge. These 2 things are there. Then what does he do? He destroys, deletes or alters. There are 3 things that you do: destroy, delete or alter any information or a computer record residing in a computer resource, or you diminish its value or diminish its utility or affect it injuriously, then he is called hacker. He is doing hacking. So what have we understood here? In hacking, number 1, there should be intention. Number 2, there should be knowledge that his act will cause a loss or damage. Number 3, he either destroys, deletes or alters a computer record, or alternatively, he diminishes the value and utility of that computer record and affects injuriously the person whom he is targeting. So that is called hacking. Whoever commits hacking, then what is the punishment? The punishment is 3 lakhs or 2 lakh of rupees. In IT Act, they have reduced the importance of hacking, the seriousness of hacking, because there is no, you are not causing death, you are not causing any crime which is punishable with life or death in IPC. So they have reduced the importance, and then they said 3 years, and plus because it is an information technology crime, and most of the people who are indulging in it are for commercial purposes, so they have increased the fine to 2 lakh of rupees. Under IPC, 2 lakh of rupees, that kind level of punishments, fines are not there. So 66 is the only provision for hacking in the computer system. Now later on, it was in 2008 amendment, it was again extended. If any person dishonestly or fraudulently does any act referred to under section 43, he shall be punishable with imprisonment for a term of 3 years or 5 lakh of rupees. Again here number of years is maintained at 3 years, but the punishment fine is increased to 5 lakhs. So you clearly understand that because you are doing this for a commercial purpose, you are being punished commercially, that is by way of money. You are doing it for money, so your punishment will be in terms of money. That is the equation. Now, what are all the different elements of this hacking? You have to remember these elements. Elements are very, very important. 1, you access a computer. 2, you download, copy or extract data from a computer. Either download something, copy something or extract data from it. Then you introduce a computer virus or a contaminant in order to damage a computer file or a resource. And by introduction of such virus or a contaminant, you cause damage to a computer, you disrupt the computer, you cause denial of services to a computer. These 3 things you do. That affects a critical information infrastructure, and that you can also lead to cyber terrorism. In case if it is cyber terrorism, it is another section is there where punishment is much higher. So this is how, these are the elements of hacking. Elements of hacking are access to a computer, downloading, copying or extracting a data from a computer, introduce a computer virus or a contaminant, cause damage to a computer, cause disruption of a computer, cause denial of service to a computer, or affect critical information infrastructure or cyber terrorism of a country. When these things are there, then it is very, very serious. Now there are various viruses, already you must have heard everywhere. Virus is nothing but a code that is put into a computer which has a .exe non-probability. It is an auto-executable file, and this auto-executable file, the moment it enters into, or the moment it is clicked on, will execute a prior instructions and then introduce a virus into introduce a negative or a bad code into the computer, and this code will spoil whatever the target computer resource is there. So the various here there are a lot of virus names are given. One of the most famous ones was 1999 Melissa virus. Before that, the viruses were more of a technical nature, and very few computers were affected with it. But in 1999, Melissa virus was the biggest, affecting almost 1 million computers. From then onwards, the number of computers that are affected by viruses have increased manifold. There was the I Love You virus, that was another very important one, which was there in Outlook program email, and it also affected millions of wherever Windows was there, it was affected. So in Unix programming, and there are also the one benefit of Unix programming is that you can stop the virus from entering into it, because it is a order based system. You don't have to just click or something a window, but you have to type in an order. Because you have to type in an order, so it is becoming difficult for the hacker to introduce a virus. So computer virus therefore is very, very common, and it is covered under Section 43C of IT Act 2000. It imposes a monetary liability of 1 crore rupees on a person. 43C of IT Act 2000 gives a liability of 1 crore of rupees on a person who, without permission of the owner or in charge of a computer, introduces or causes to be introduced any computer contaminant or a virus into any computer system or a network. Computer virus therefore means any computer instruction, information, data or program. Computer virus definition here is, you have to by heart it anyway. Any computer instruction, it can be information, it can be data or a program that destroys, damages, degrades or adversely affects the performance of a computer resource or attaches itself to another computer resource and operates when a program, data or instruction is executed and some other event takes place in the computer resource. So computer contaminant is a wider term used for computer virus. It contains a set of computer instructions that are designed to modify, destroy, record, transmit data or program residing within a computer system or a computer network, and by any means to usurp the normal operation of the computer system or a computer network. Section 43 imposes a strict liability upon the person who plants any computer virus or a contaminant. Now here the issue is the mens rea, the mind, the mental element. Here they have made it a strict liability. Strict liability is there under Section 43, and they said under 66 what they have, under amended version what they said, whoever does an act under Section 43 is punishable if it is hacking. That's what they made under 66 for 3 years and 5 lakhs. So 43 says it is strict liability. That means mens rea need not be proved. There need not be any element of malicious intent. If you do that particular act, you are liable. You will be punished. So that is what has been indicated. Yes, now there are some fundamental questions that have to be asked in case of computer virus. One is, what is the level of general awareness in our country? How many people who use computers are aware of antivirus that should be used? What is the general level of consciousness among people that before sending a computer file to another CD, floppy or a pen drive should be checked whether it is virus is there or not? With computer contaminant and virus floating everywhere in floppy, CD, pen drive and internet, how will it be a prima facie as to who introduced or transmitted the contaminant? How do you find out? Whom will you? Because supposing I receive a file with I love you virus and I send the file without opening it to somebody else as a group, then all of them will be infected. If they open it, I didn't open it, I just forwarded it. The entire document with that file I have forwarded it. Am I liable? That becomes a very big issue. Are our law enforcement agencies and judiciary equipped to determine source of the computer contaminant and virus? So how do you find out the source? So that becomes very, very difficult because most of the computer viruses are prepared, engineered by very, very intelligent people, and they may be sitting anywhere in the world, and this virus may be spreading all over, and anybody who is forwarding it becomes a part to the chain. And then this 5 lakhs is heavy, and Section 43 without any mental element, without taking into account mental element, that is also a very strict, harsh punishment. Now, in the case of finance, cyber crimes related, or in economic science, economic crimes, computer is used as a source, as a method, as a means to commit a lot of financial crimes. Now what PricewaterhouseCoopers has said is, an economic crime committed using computers and the internet, it includes what? It includes virus, it includes illegally downloading files, includes phishing, it includes farming and stealing personal information like bank account details. It's only a cyber crime if a computers or internet play a central role in the crime and not an incidental one. That's how they have understood. But in our Indian Information IT Act, because the mental element is not there, then if you do that particular act, you are liable. There is a slight difference between the position that is there abroad and that position there here in India. Abroad, still that mental element is taken into account. And economic crimes affect everybody, that we have to understand. And cybercrime, why people attempt it is because the risk is very low and rewards are very high as compared to traditional crimes. And what are the financial cyber crimes? Are one, cheating online, credit card frauds, another, money laundering, another, forgery, another, online investment frauds. These are the items that are punishable under IPC and IT Act. Now let us see what are they. One is cheating. Cheating is that you offer something that is of no value for getting the money. You take the money and offer something of no value to the other person. That is cheating. Second is credit card frauds. Credit card frauds is there are a lot of advertisements that come. You are eligible for credit card of 5 lakhs, 3 lakhs, and then you say you give all these documents and then you join. Then these details are available with him. You start using it and your money is linked to it and somebody else will use it. Credit card fraud can happen in one way, that they copy your credit card and make a duplicate card, or they copy your details and then use it online without your knowledge. Okay. Or they get these credit card details from a third party or a credit card issuer and then use it for their purpose. There is different kinds of credit card frauds that happen. Then money laundering. Money laundering is nothing but converting black money into white money. Now 2000 rupees has been abolished. Now what people are doing on money laundering? Though 2000 rupee has been abolished, there is one small provision that is given, that businessmen can still accept it. So most of them who have 2000 rupee notes are rushing to the gold jewelry shops and buying jewelry and gold, even at a higher prices. Earlier it was 60,000 rupees, it went up to 75,000, 80,000 rupees, and some places even 1 lakh per gram, per 10 grams. So based on that, they are buying by giving these 2000 rupees notes and then buying gold. And they will deposit in their account saying that it is normal business income. So that's how the cycle continues. Maybe up to September it will continue. Next is forgery. Another financial this thing is forgery. Forgery can be by way of copying the signature or by way of copying your digital signature certificate or electronic signature certificate. Okay, this thing kind of forgery can happen. Then online investment frauds are there. Investment frauds, you float a company or you float a particular app and then ask others to join. When they join, you pay 10 rupees, and you show them some profit. Once they get profit, they get, and greed comes in, and they start investing lakhs of rupees and they lose all the money. These are the kind of investment frauds that happen. Now, in general, what is a fraud? Now we have to understand what is a fraud. And fraud is to deprive a man of his right, either by obtaining something by deception or by taking something wrongfully without the knowledge or consent of the owner. Okay, one is deception, second is taking something without consent. Then to withhold wrongfully from the another what is due to him, or wrongfully prevent one from obtaining what he may justifiably claim. That one is act, another is the stopping from act. Right? Then to defeat or frustrate wrongfully another's right to property. And whenever the words fraud, intent to defraud, or intent to expose some other person is actual or possible injury, the intent and object of the fraudulent person is every cause to his own advantage. Now here, intent is there, object is there, to do a particular thing to your benefit is there, and to do something to stop others from getting a benefit is also there. So these are the four different kinds of things. You have all these things are frauds. A test of a fraud is a fraudulent character of deception is the criminal purpose. Is whether it is to deceit, derived from advantage out of it, okay, which the other person would not have done any particular act if he would have known that this particular thing is a fraudulent thing and I should not do it. So the modus operandi to gain advantage is the main thing. In all scams and all financial crimes, the modus operandi will be to gain advantage, undue advantage at the cost of the other. Now sections 415 to 420 IPC, they deal with law relating to cheating. In the case of internet scams, relevant sections relating to crime cheating, that are impersonation 416, cheating with knowledge, a wrongful loss may ensure to a person whether interest if offender is bound to protect, section 418, they are applied. Fraud is clearly defined under Indian Contract Act 1872, section 7. Fraud under section 7 Indian Contract Act says fraud means and includes any of the following act committed by a party to a contract or with his connivance by his agent, with intent to deceive another party or his agent and to induce him to enter into a contract. So this is fraud. Fraud is you deceive him or you make him enter into a contract which is not beneficial to him. Under IT Act 2000 deals with the crimes relating to internet fraud and online investments under section 43D, 65 and 66. 65 and 66 are punishment sections. 43D is the mental element section. 43D penalizes a person who damages or causes damage to data. So it is a strict liability. If you cause damage to data of a computer, any computer resource, you are punishable. 43D. 65, 66 will indicate what are the punishments given there. Okay. Damage then under clause 4 is the explanation says what is the damage? Damage means destroy, alter, add, modify, rearrange. Destroy, delete, alter, add, modify or rearrange any computer resource by any means. Therefore, unauthorized alteration of data would come within the 43D. It is sufficient to cover computer crimes of false or market manipulation, stock manipulation and things like that. Computer source code is defined earlier. Okay, now financial cybercrime in recent cases. 2005, a student of MBBS of Bangalore was arrested for posting juicy advertisements for high performance laptops and different websites. Many took the bait and made online purchases, but laptops never reached them. He made several lakhs in the bargain. In 2006, Delhi High Court passed injunction order against 4 lawyers, including a Nigerian national, restraining them and representatives from using in any manner the proprietary data and confidential information stolen from their erstwhile employer, Tatus and Company, advocates. They have ex-employees, that's a very normal way. Ex-employees, when they are employee, they are privy to a lot of information. They copy it into a particular laptop or a pen drive, and then if they are removed or they go leave the company, they use it elsewhere to get money. And Chennai Cybercrime Police arrested 4 persons who formed part of a UK-based gang for withdrawing money from ATMs through use of forged credit cards. 2011, 2 persons who fraudulently made online transactions with credit card of their customers were arrested. In 2013, a conman from Maharashtra cheated ICICI Bank customer by obtaining their credit card data, fallen into the Delhi police net after illegal online transaction over 1 crore in the past 1 year. So next is, this is all hacking. Till now we have seen hacking and computer online frauds, financial frauds. Next is phishing and wishing. Phishing is, duplicacy, right? And wishing is using video. In that is wishing. Phishing and wishing come together. It's only the means that is different. Phishing is a form of social engineering. It is characterized by attempt to fraudulently acquire sensitive information like password, credit card details by masquerading as a trustworthy person or a business in apparently official electronic communication like email or a website or instant messaging, IM. The term phishing arises from the use of sophisticated lures to phish for users' financial information and passwords. The act of sending an email or a user-friendly, falsely claiming to be an established bank like ICICI Bank or HDFC Bank in an attempt to scam the user into surrendering private information. As you apply for 7 lakh of loan, this application give your email address, you give your name, mother's name, वगैरह, give your account number, give your Aadhaar card, give your PAN card. If you are using, have you been using any credit card, then give the credit card number. Like that. So many form they are asked you to fill up. When you fill up the entire form, all your information is with them, and that will be identity theft. The email directs the user to visit a website where they are asked to update the personal information like password, credit card, social security, bank account number, And then website, however, is bogus and set up only to steal the user's information. The motive behind phishing is that people will share their credit card information, password, bank account number, thinking that they are sharing with a legitimate organization, the bank or so. But this particular site itself is a duplicate. The phishing is a criminal practice using social engineering and voice over internet protocol. If you are using voice over internet protocol, VoIP, to gain access to the same phishing, whatever you are doing, for accessing the private, personal, and financial information, it is called voice plus phishing is phishing. Phishing exploits the public's trust in landline telephone services, which have traditionally terminated physical locations and are known to telephone company. The victim is often unaware that VoIP allows the caller ID spoofing. So this thing happens, and a judgment is there. Uma Shankar versus ICICI Bank. The award was given for 12.85 lakhs. Their bank contended that the issue involved customer negligence and did not fall under jurisdiction of the adjudicator. Adjudicator held the offence is under ITA 2000, falls under jurisdiction. Honorable adjudicator proceeded to accept the petitioner argument. The bank had not exercised due diligence. So here, whenever a bank loses money, bank customer loses money, it is very easy to hold the bank liable, because if it is proved that the bank did not exercise due diligence, then it becomes liable under section 85 to pay compensation. Most methods of phishing are use forms of technical deception designed to make a link to an email appear to belong to a spoofed organization. How do you check up for phishing websites or phishing URLs is the most important part is the spelling mistakes. Okay. If you see, check for the spelling mistakes, some extra A or A that is should be there is not there, things like that, then you will be able to find out. But it is very difficult anyway. Nowadays there are many softwares which indicate a phishing website or phishing URL link, and before you even Google has come out with a check where they say this is a dangerous link, please do not touch it. Such messages also come in Google also. Phishing attacks are becoming very common form nowadays in internet-based banking. Banks have been largely forcing customers to believe the liability of phishing should be borne by customers. But when you go to court under IT Act, after amendment of 2008, it is wrongful loss to the customer, then the contravention will go under 43 and the banks are supposed to pay. In Bangalore, Chennai, Hyderabad, several complaints have been registered and they have all resulted in liability to the bank, not to the customer. So, negligence, lack of due diligence, or acting on a particular instruction where it is not attached with a digital signature, these are the things that make the bank liable. Next is denial of service attack. There are two things: denial of service and distributed denial of service, DDoS. DOS and DDoS. DOS is you have every computer has you get your connection from a internet service provider. An internet service provider gives you a particular bandwidth in which you have to operate your computer. Now, when you know that this is the particular bandwidth, it will be able to take a load of say 1000 emails at a particular point of time. If you flood that particular computer with 10,000 emails on any particular day, then the entire email box will be full, the bandwidth will be used up, and then you cannot operate, your computer system will crash. So that is how a computer of a company or a business organization is made inoperable. It cannot be operated by his customers. So if they lose business and they become denial, that becomes a denial of service. Now, many DOS attacks such as ping of death and teardrop attacks exploit limitations in the TCP/IP protocol. In a typical connection, the user sends a message asking the server to authenticate it. Server returns the authentication approval to the user. User acknowledges his approval and is allowed onto the server. So this is the pinging mechanism where you ping the server and it gives back an authentication. If it is correct, then it will allow you connection. In a denial of service attack, the user sends several authentication requests to the server, filling it up with thousands of requests, and all requests are false return addresses. So server can't find the user when it tries to send the authentication approval. the server waits sometime more than a minute before closing the connection. When it does close the connection, the attacker sends a new batch of forged requests. And the process begins again. Again it will close down. So these are three basic types of attack under DOS. One is consume the computational resources of the bandwidth, disk space or CPU time. You can consume either one of the either bandwidth on the internet or disk space on your computer itself or CPU time based on your whatever CPU you are using. Okay. Then disruption of the configuration information like routing information. Routers can be affected. Then disruption of the physical network components. Okay, these are three ways. Physical network components is very rare unless it is done by, say, people who are spying on behalf of a country or other. But normally what happens is router can be affected, bandwidth can be affected, then disk space I don't think that much, but CPU time can be easily affected because every CPU has a speed with which it can, number of requests that it can process. If it goes beyond that, it will crash automatically. Then there is a distributed DDoS, distributed denial of service attack, where multiple compromised systems flood the bandwidth or resources of a targeted system. And usually one or more web servers. These systems are compromised by attackers using variety of methods. Malware can carry DDoS attack mechanisms. One of the more well-known examples is MyDoom. Its DOS mechanism was triggered on a specific date and time. The system may also be compromised via a Trojan, allowing the attacker to download a zombie agent. Attackers can also break into systems using automated tools that exploit flaws in the program and listen for connection from a remote host. This scenario primarily concerns systems acting as servers on the web. It is important to note the difference between DDoS and DOS. When an attacker mounts a Smurf attack from a single host, okay, then it is DOS. In fact, any attack against availability would be classed as a DOS. On the other hand, if the attacker tries 1,000 zombie systems to simultaneously launch Smurf attacks against the remote host, then it is called DDoS. Okay, one attacker from one computer system is DOS. One attacker through 100 computer systems attacking one computer system is DDoS. The major advantages to an attacker using a distributed denial of service DDoS is multiple machines can generate more attack traffic than one machine. Multiple attack machines are harder to turn off than one attack machine. So the person who is defending will be unable to defend. That's the DDoS. Next crime is data theft. The biggest case of data breach or data theft identity theft was exposed in 2009. A 28-year-old American, along with his two Russian accomplices, arrested for masterminding global scheme to steal data of 130 million credit and debit cards, hacking into computer system of major companies of supermarkets, 7-Eleven, and payment system companies. Then data and information are valuable assets in the digital age. The latest saying is that data is the new petrol. Earlier, petrol was the very important thing for running a business or a transport or a nation. But now data has replaced petrol as the new currency, which is required to run in a digital business. So business secrets are there, technical know-how is there, designs are there, music, films, books, personal data, usernames, credit card numbers, passwords. These are all the property, online property. Money, time and effort and creativity are required to create them, and anybody who steals will steal all your money, time, data and effort and creativity. So data is like the chameleon that plays comedy. Under 378 IPC, theft is there. This data theft is now first covered under IPC 378, then under IT Act. Okay. Now what does the 378 theft IPC say? Whoever intending to take dishonestly, that is, one issue is taking dishonest. One is taking. Second is taking dishonestly. Any movable property. What he is taking? He is taking a movable property, not immovable property. Out of the possession of any person, possession of the rightful owner, without that person's consent, moves that property in order to such taking is said to commit theft. So in a theft, even if you just shift it from position A to position B within the same computer resource also, that means you shift it from one folder to another folder. That is also theft, like that. So this is under IPC. There are 3 or 4 things that you have to see. One is you don't have consent, number 1. Number 2, you have a dishonest intention, number 2. Number 3, it is a movable property, movable asset, and you shift it from one folder to another or shift it completely out of the computer system. Either of the two you do it, and you do it without consent, that is theft. So there can be theft in law only for movable property, not for immovable property. That distinction you have to understand. And in Avatar Singh versus State of Punjab, stealing of electricity is also considered as theft. Earlier, before to this Avatar Singh case, the theft was only with regard to tangible items. But with Avatar Singh case, electricity was also subject to theft. Electricity was something that is not tangible, you cannot see it. Okay, so but still it was held to be under Electricity Act as theft. Now, applying law of theft to the information and data. How does it apply? So, if it is stored in a floppy, CD or a pen drive, they become part of movable property. Then you steal them, then that is theft without consent. If the computer itself is stolen, then that is also movable property, and that too can be theft. Stealing data information online is not a theft under 378 IPC, unfortunately. So for that, IP Information Technology Act had to come in. So what are the ways in which data information theft is committed? Is first unauthorized copying of data, making unauthorized subsequent copies, making a copy and dishonestly sending it over online, and unauthorized copying of data into floppy, pen drive, vagara, and taking it away, stealing the computer itself, or data information already reside in a mobile storage medium or floppy and taking that floppy. So similarly, offence under dishonest misappropriation of property under 403 IPC, the property must be mobile, that is tangible. So IT Amendment Act 2008 tried to reduce that, remove that problem regarding if that some definitions of theft where no physical item has been taken, no movable property is taken, just online it is taken. So that now they said, the definition they said data theft, they brought it into section 66, that was section 43. Data theft has been now defined. Here, what does it say? If any person without permission of the owner or any other person who is in charge of a computer system or a computer network, 1. downloads, 2. copies, 3. extracts any data or database or information from such computer system or a network, then the information or data held or stored therein in a removable storage medium. If you do it, then it is data theft. If he steals, if he conceals, if he destroys, alters, or causes any person to do the same thing, steal, conceal, destroy, or alter a source code or use for a computer resource with an intention to cause damage, and that's also data theft. Another form of data breach is a breach of trust with respect to data and information. IT industry primarily deals with data and information in different forms. Okay, IT industry, their lifeline is data. There are 2 cases that have come to light. First is travelocity.co.in versus ClearTrip, and second is Justdial versus Infomedia. In the first case, Travelocity filed FIR with Gurgaon police that CEO ClearTrip and MD Desya alleging criminal breach of trust, data theft, cheating, criminal misappropriation, and criminal conspiracy. MD Desya had passed on the company's intellectual property, trade secrets, sensitive data, and proprietary technology source codes, their entire hotel business model and projections to CEO of ClearTrip. In the second case, it is reported Justdial had obtained injunction against Infomedia for running website askme.in. As it was alleged, Infomedia 18 had copied Justdial database onto its newly launched website askme.in, thereby violating Justdial's database copyrights. Injunction was granted ex parte by the Honorable High Court. So you understand these 2 things. 1. A CEO of a company has taken with him all the intellectual property of a company and gone into sold it to a next company. Okay, ClearTrip to AskMe, and then Justdial to AskMe. Right. So next is, this is how you have data theft. Now you have data diddling. Next issue is data diddling. Data diddling involves changing data prior or during input into a computer. Data diddling means diddling normally, all the small circles that you make. Okay, so data diddling is like that. They have no meaning, but they change what is there actually. So data diddling is changing data prior or during input into a computer, and the information is changed from the way it is entered. Okay, you enter something and it gets entered something else. The culprit can be anyone involving in the process of creating, recording, encoding, examining, checking, converting, transmitting data, because data from a person to a computer goes through all these processes. That means you create data, you record the data, you encode that data where coding is there, you examine it, you check it, and then you convert it and transmit it. In all these stages, data diddling can happen. It is the simplest methods of committing computer related crime. It requires almost no computer skills. Despite the ease of committing crime, the cost of the party can be considerable. Next is salami attacks. The salami attack is a series of minor attacks, data security attacks, that together result in a larger attack, a fraud activity in a bank. In a bank, a typical fraud activity salami attack is you will introduce a program into the computer of the bank where, supposing amount of 100.20, 100 rupees 20 paisa is to be created. So what he will do is he will introduce a particular program whereby 0.20 is credited to a different account, that is the person who is doing the crime, his account. 100 rupees is credited to the person's account. So actual person will get his 100 rupees, he is expecting 100 rupees. He doesn't know that 100.20 should be credited. So he thinks it is rounding off has been made and 100 rupees is credited, so he will be happy. 20 paisa will go to the criminal's account, and this 20 paisa, this 5 paisa, 2 paisa, 3 paisa, 10 paisa, 80 paisa, these things from all the account holders of the bank will go and get credited to the criminal's account. So these small bits and pieces of money, less than 1 rupee, will, when it is credited from hundreds and lakhs of customers of the bank, it amounts to a sizable amount, and then the criminal will take away that money. So that is called salami attack. Crimes involving salami attacks are difficult to detect and trace. These attacks are used for commission of financial crimes. Normally a bank employee does it. Bank employee inserts a program into bank servers, deducts a small amount of money. It can also be done 5 rupees every month. No, we are used to these amounts that are deducted by bank. The ledger folio charges and number of transaction charges, then interest debits, the tax debits. There are a lot of debits that are made by the bank, and we normally used to such debits of 5 rupee, 10 rupee, 1 rupee, 0.2 rupee, 20 rupee, 5 rupees, and we don't really bother. So this is bank charges, right? The bank charges and then debit it, and we don't really complain about it. So the bank compliance will make money by that way. An employee of a bank in USA was dismissed from his job, disgruntled at having supposedly mistreated. The man first introduced a logic bomb into the bank systems. The logic bomb was programmed to take 10 cents from all accounts in the bank and put them into an account whose name was last name Ziegler. The amount being withdrawn from each of these accounts in the bank was so insignificant that neither the account holder nor the bank official noticed any fault. It was brought to their notice when a person by name Ziegler again opened his account in that bank. He was surprised to find crores of rupees in his account. Next, email bombing. In internet usage, email bomb is a form of net abuse consisting of sending huge volume of email to an address in an attempt to overflow. It's something similar to DOS, but it is against an email address. It's not against a particular business computer, a business server, but it is against an email box, mailbox. Mailbox is overwhelmed. The mail bombing is the act of sending email bomb. The term shared is sending actual exploding devices. Mail bombing is sometimes accomplished by giving victims email addressed to many spammers. So it is more personal in nature. email account of the individual is lost. Maybe it may result in a loss, it may not result in a loss, but his email account will get closed, and he may have to again open another account or clean it and then start it. Next is email spoofing. Email spoofing means describing, you will have, if a particular mail is to come to me, Mr. A, then Mr. B will have, Mr. B will make it look as if it is Mr. A, and that is called email spoofing. Email spoofing is a term used to describe fraudulent email activity in which the sender addresses other parts of the email header are altered to appear it originated from a different source. That is, it comes from B. The header is manipulated to show that it has come from actually from A, and the person who is receiving expects it to come from A, then he will be happy that he received the email, but it is not an email which actually he is supposed to reply. Now here certain properties of the email such as from, return path and reply to fields, they are manipulated. It's a kind of a forgery. Email spoofing is possible because Simple Mail Transfer Protocol SMTP is the main protocol used in sending emails, does not include an authentication mechanism. In SMTP there is no authentication. So that's why it can be easily done. Flipkart CEO Binny Bensel's email account was spoofed. Official statement from company stated CEO's email account has been spoofed and the spoofed email does not originate from the real source. Next is logic bombs. In a computer program, a logic bomb is a programming code inserted surreptitiously or intentionally designed to execute or explode under circumstances like lapse of a certain amount of time or the failure of a program to respond to a program command. Software that is inherently malicious, like virus or a worm, often contains logic bombs that execute a certain payload at a predefined time and some other condition is met. This technique is used by a virus or a worm to gain momentum and spread before it is noticed. It was done by April Fool Day, right? And a particular time bombs, Trojan horses, logic bombs, they are all, mostly they do it on April Fool's Day. There was one Chernobyl virus also, it was a logic bomb. Next is internet time theft. We have heard about, internet, there are some agencies, some companies which need to run lot of their programming. They need lot of computer resources, but they don't have that much of money to buy that much of computer resource. So what they do is, supposing you are doing a space program, you are doing a, some kind of a program where a lot of variations are to be done. Then they put out a request. So whoever has got spare time, spare resources available, please download our app, and whenever you are not using your computer, that app will use it for our purpose. It is a useful purpose for public good, and it will, so you are studying either the space, you are studying about things like that, where many things are to be seen, it will be useful. But it can also be done, this is called, this is normally that is done where positive thing is there. Then this can also be a crime. Internet time theft can also be crime. It is under 43H. There is a civil liability for this offence under 43H. As the case is Colonel Bajwa case in IT, before IT Act 2000. We also do a lot of times, we find out that among friends internet time usage is always done. If you have a internet connection, everybody else will use it. With permission, if you use it, it is okay. Without permission, it is used, then it becomes an internet theft. Then cybercrime, IPRs, intellectual property rights, domain name violation and passing off. Domain name violation means you are copying somebody else's domain name, or passing off means you are putting up your website, but you are showing as if it is somebody else's website. That's called passing off. You have your own, you are a smaller company, but you pass off your domain name as somebody, a big company. That is called passing off. Now, word domain is the field of action, but it is here domain name is your address of your website. Then software piracy. Next thing is software piracy. Is original literary, dramatic, musical work. Copyright is given for these things. Original literary, dramatic, musical works, artistic works, computer programs, cinematographic films, and sound recording. So under Copyright Act, you are protected when you just write a program, a computer program. That if it is copied, if it is copied in somebody else or sold without consent, if it is used by somebody without consent, then that becomes a copyright violation. You can file a case under Copyright Violation, Copyright Act, Section 2 FFC. Computer program under 2 FFC says a set of instructions expressed in words, codes, schemes, or any other form, including a machine readable form, capable of causing a computer to perform a particular task. Computer programs are a product of intellectual process, they are copyrightable material. Now, what do you do when copyright infringement here? You reproduce the original owner's software and packaging of that software. You reproduce or burn the original owner's software onto a blank disk. Reproduce a number of such owner's program on a single CD-ROM known as compilation CD, or readable CD or final CD. Most of the movies, copying of these movies, copies of MS Word, MS Office, Word, Windows, this is all done under this Copyright Act. 63B of Copyright Act 1994 amendment, it includes infringing of copy of the computer program. 43B of IT Act provides for compensation and imposes a liability to pay damages without permission if you download, copy or extract any data. Next, copyright in digital music. Digital music is copyrighted by a group of people or musicians, and they can initiate a case whenever some other person copies your or plays your music. So here it is storing of MP3 files, searching of MP3 files, transferring copies of MP3 files. All these three things are problems. But what can be a normal usage which can be allowed without saying it is a copyright violation is that sampling, if you take a temporary copies, space shifting, okay, or permissive distribution. These three things are allowed. They are not a crime. And fair doctrine, the purpose and character of the usage, fair doctrine usage is that purpose and character should be there, nature of copyrighted work should be seen, amount and substantiality of the portion should be seen, effect of the use on the market should be seen. So these are the things that have to be seen. Then right of reproduction in database. A database is a collection of data which is organized. A few cases given here. Now, mobile technology, wireless technology, over the cell phones. These are all same things that happen with will happen with a computer can also happen with your mobile phone. Physical mobile phone theft is a physical loss. It comes under IPC. But taking data out of it is a computer loss. It is under IT Act. Use of mobile and wireless technology in terrorist activities, that is now cyber terrorism. Satellite phones are used. SIM cards and fake addresses are used. Then rechipping and cloning of mobile phones, IMEI number. You identify a particular phone by its IMEI number, that is Mobile Electronic Identity Number, International Mobile Electronic Identity Number. Okay, so this IMEI number, it is a unique number, and if you copy it, you rechip it, and then it can be used for terrorist activities. A clone can be made, and clone can be used for terrorist activities. Then SMS spoofing is there, like email spoofing only. So these are all the computer crimes. So we have completed all the computer crimes, and this material also I have already shared. You can go through it. Any doubts you have, you can ask. Yes, Swati, you have raised a hand. Any question? Yes? Acha, okay. Now, is it okay in our lecture? You understood? I think we can close now.
Yes, sure, sir.
You please go through it, whatever material I have given. It is sufficient, lot of material is there. I have given you in 3 forms. One is only one line answers, second is only definitions, third is a detailed thing. All 3 I have given about IT Act. And IT Act summary also I have given. So these 4 things put together, I think it will be useful to you in any activity that you want to do. Thank you.
Oh, thank
You
you.
can leave.